This webinar is using regulatory case studies as a learning tool in pharmacy. I'm David Brushwood with the University of Florida College of Pharmacy. The opportunity we have with legal case studies is that we can learn from them and apply what we learn in our practices so that we don't become as unfortunate as others have been in the past, running into regulatory difficulties. So we study these past legal cases not because we want to in any way chastise people for having gotten into trouble. We don't want to make fun of them for having been involved in regulatory activities. We don't want to in any way criticize them. What we do want to do is learn from their experiences. And I think we probably all share this idea that if we make a mistake, the best thing you can do is learn from it. So what I'm going to be doing in this webinar is suggesting that we have available to us some published, some public legal cases involving regulatory noncompliance by pharmacists. And we might as well use them. We might as well take an opportunity to learn from them and improve in the future, not in any way criticizing the people who were involved in these in the past, but using their experience to hopefully avoid experiencing the same thing ourselves. So we have three learning objectives. The first is to describe how case studies can be used effectively to teach important lessons related to regulatory compliance in pharmacy. The second is to list the critical steps that are necessary for effective case study review with pharmacy personnel. And the third is to discuss compliance strategies that can be implemented following lessons learned from case studies in pharmacy regulation. So first of all, let's talk about the role of the pharmacy regulatory specialist. What is it that the pharmacy regulatory specialist can do to improve the quality of pharmacy practice in which both pharmacists and technicians participate? Well, the first thing a PRS can do is be an expert on regulations and compliance strategies. And that's wonderful, having an expert. Having a designated person who is the person with this expertise is fantastic, but it's not enough, because that person also has to monitor developments in pharmacy regulation. Pharmacy regulation is a very dynamic process, and the PRS needs to know not just what the regulations are and effective compliance strategy to meet the requirements of those regulations today, but also how it is that those regulations are changing so that we don't just meet requirements today, but place into effect strategies that will be effective tomorrow based on what we see as the evolution of pharmacy regulatory requirements. The PRS is the writer of policies and procedures and is a gentle enforcer of them by just reminding personnel that these policies and procedures exist and here's where you can find them. Probably most importantly for our discussion today, the PRS is an educator, a person who takes the opportunity to explain what it is that is required of pharmacists and pharmacy technicians and how it is that these requirements can be met. And the PRS is also a consultant. So after the educational opportunity has been taken advantage of, if there are questions, the hour after, the day after, the month after, there's been a specified educational opportunity, the consultant, the PRS, can answer those questions. The PRS also functions as a liaison between management and practitioners, so that if there are resources practitioners need, management can be told of them and why those resources are necessary to comply with regulatory requirements. If management has a specific need for practitioners to modify their behaviors so as to comply with requirements, then the PRS can be the one to communicate that need. And then the PRS can serve as a liaison between regulators and practitioners So when regulators say there's a particular way of going about things that we think is important in order for there to be recognized compliance on our part, the PRS can say, well, that's fine. I will help the practitioners who are within my area of responsibility understand what that requirement is. And by the same token, when the practitioners say that just doesn't work, it's impractical, the PRS can go back to the regulators and say, let's see if we can work out a way to meet your needs that doesn't get in the way of effective pharmacy practice. So how is it that the PRS can go about promoting compliance? There are several ways that this can be done effectively. One is by creating a culture of compliance, making pharmacists and technicians you work with want to comply. That can come from respect for the rules, and that's not necessarily as easy as you might think it is. And you've probably seen recently in the media that there has tended to be a culture of disrespect for government, disrespect for the rules. People saying, I'm not going to comply because I think the government doesn't have the people's best interests at heart. And the media cover these stories, and surprisingly to me anyway, there are oftentimes quite a few people who say, I agree. The government, particularly the federal government, is completely out of hand. And as a matter of civil disobedience, we should just refuse to comply with the requirements that the government has imposed. Not a good idea in pharmacy to do that. Not a good idea to simply disrespect the requirements and have a culture of non-compliance. So what a PRS can do is provide incentives and perhaps deal with some of the frustration by listening to people who have become frustrated with requirements that seem not to serve any useful purpose, listening to their explanation and then trying to explain to them why, despite these legitimate concerns they may have, it's necessary here in this practice for us to go ahead and comply. Another way to promote compliance is to explain the basis of the regulations. It may be that pharmacists or technicians in the past have just been told, here is what you need to do. I don't want to talk about it. I just want you to comply, period, end of story. And that's not good enough. That's not a rich enough explanation. They need to know the basics, the basis of the regulations. Why is it that this regulation came into being? What is it about the regulation that protects the public? Why is it that this regulation reduces risks for patients, it reduces risks for pharmacists, and it reduces risk for prescribers? And then encouraging attention to regulatory issues. Pay attention. Pay attention. When you're considering clinical care, when you're considering processing the orders of medications for patients, pay attention. Please don't consider only the clinical aspects or the distributive aspects, but consider the regulatory aspects of what you're doing as well. Developing effective strategies for compliance. So what the pharmacy regulatory specialist can do is help develop strategies that will allow the personnel to pay attention to regulatory issues. And these might be IT strategies, for example, so that when an order is entered into the computer and there's a potential problem with a regulatory requirement, there's an alert that's provided to the pharmacists and technicians so that they understand, I better pay attention here because this alert has cautioned me that there's a potential regulatory issue. Now we have that with clinical issues and we have that with distributive issues. Perhaps what we need to do is have that with regulatory issues as well. Teaching steps to promote regulatory compliance. So we're always teaching. The pharmacy regulatory specialist never takes a day off from teaching. There may be some in-services or meetings at which the central focus is teaching, but teaching happens all the time, every minute, every hour, every day, every week. And then auditing to determine success with strategies. So the PRS periodically examines what it is that's happening and tries to figure out how well are we doing with these strategies. Are things working or are things not working? based on data that are available to the pharmacy regulatory specialist. And then finally, reporting back, a feedback loop. People who are being required to do things want to know, are there issues that you'd like to bring up? Should we talk about this? Are there strengths and weaknesses that we need to address? Pats on the back for the strengths. Way to go. Attaboy, attagirl. And we have an opportunity here because we do have some weaknesses. So let's figure out what it is together that we can do to address those. So let's focus on the teaching role. The teaching role of the pharmacy regulatory specialist. And recognized, first of all, that, as I said a minute ago, the basis of the regulations, the place they came from, the purpose of them, the reason for their existence is an important aspect of teaching. Perhaps there have been some tragedies, some crises that have occurred, and it may seem that a new regulation is just busy work, pointless, and irrelevant to pharmacy practice. But what the PRS can say is, actually, that's not the case. There is a basis for these regulations. There have been some problems in the past. We haven't experienced those problems here, but others have elsewhere. And we need to make sure that we don't have the same experiences that they have. The structure of regulatory agencies. Pharmacists and technicians need to understand what it is from the perspective of the FDA, from the Board of Pharmacy, from the DEA, that needs to be done, because they have pressures on them as well, and we need to help them meet their goals. One way to comply with requirements is to understand the structure of regulatory agencies, the goals that they may meet, and what it is that we can do to make them look good. Because if we can make them look good, they're going to be happy. And that's what we want. We want them to be happy. The next thing that can be taught is the regulations themselves. What are the rules? And almost invariably, there will be ambiguities. There will be interpretations necessary. And there are online mechanisms to determine what the latest interpretations are of certain rules. There are conferences that a PRS can go to where these things can be learned. There are continuing education programs that pharmacists can participate in to learn this. The PRS most likely will be the one who will do that and then bring that information back. So what the rules are and what they mean can be explained. Then the value of attention to regulatory compliance, why it is that it makes good sense for us to do this. It is a waste of time to not comply and then have to pick up the pieces afterward. It's much more efficient if we go ahead and comply today rather than spending the time to clean up a mess we made. And case studies and noncompliance. Now, this is what specifically I want to talk about in this webinar. There are examples of things that have happened, and they're scary, and they're attention-getting. If you have anybody who you're responsible for teaching about regulatory compliance in pharmacy, any pharmacists or technicians, and you're getting trouble having them buy in to the idea that you're helping them, that the service you provide is useful, use some case studies, some legal case studies as examples, and you'll get their attention. They'll think, whoa, this is not good for this to have occurred to other people. I'm glad it didn't happen to me. Whew, I need to pay attention to this pharmacy regulatory specialist and see what I can do to avoid having this happen to me in the future. Because in almost all of these cases, pharmacists and technicians can see a little bit of themselves and reflect on the reality that what happened to another could have happened to them. And then learn lessons from case studies. So now that I have your attention, now that you've bought into the idea that bad things can happen to good people, what is it that we can do to learn from what has happened to others and to avoid having that happen to us? And specifically what that means is we need to apply what we've learned from these case studies to practice. So implement specific practices, specific techniques that can avoid having this sort of thing happen to us in the future. It's about change. And people don't really like the idea of change, yet sometimes change is inevitable, and it might be the case that based on one of these legal assessments that you have done, others realize we've got to do it differently in the future than we've done it in the past. So, where do we find legal cases? Where can you find legal cases? I mean, they're available. These are not secret. They're not like medical records. Sometimes pharmacists and technicians are accustomed to the idea that descriptions of things that have happened are confidential and they're maintained in secret places where the public can't get a hold of them. And that's absolutely true of medical records, not true of legal records. These are made available specifically for the purpose of allowing people like us to learn from them and do better in the future than others did in the past. So where do we find these? If they're so available, where do we get them? Well, one thing you can do if you have a lawyer at your company is ask the lawyer to use a fee-based system that lawyers all have access to. And I don't need to explain to you how to do that. Your lawyer can do that. What we have available to us, if we're not lawyers, is a number of other sources that are not quite as good as that, but the best of which is FindLaw, findlaw.com. And in findlaw.com, you can get full cases, the entire court record. So that's a really good resource, and there are various search terms that you can use to find what you might need based on certain issues that you're facing and the opportunity to use lessons of the past to learn for the future. State and federal court websites also have these legal cases. So your state court of appeals, your state Supreme Court, federal courts, federal district courts, federal appellate courts, the Supreme Court of the United States has websites that you can go to, searchable websites that you can go to and find legal cases that you can download, print off, and use in instructional activities. The DEA Diversion Control website has a list of disciplinary actions against physicians, against manufacturers, wholesalers, pharmacists, pharmacies. They're published in the Federal Register, but they're gathered on the DEA Diversion Control website and made easily accessible there. Google searches. You can just go to Google and put in whatever it is that you happen to be interested in. For example, legal case pharmacist supervision of technician or something like that, and see what you get. There are some summaries that you might be interested in that are published in U.S. Pharmacist and Pharmacy Today. My column is in Pharmacy Today each month. But those are summaries. They're not the rich, full case that will probably help you out the best. The American Society for Pharmacy Law has available legal summaries. It's for members only, and you'll have to join ASPL in order to get those, but they do make those available. And then there are newspaper articles. Problem with newspaper articles is they're sensational. They emphasize stuff that may not be true. Reporters get things wrong all the time, and you just don't know if you've gotten the true story when you go to a newspaper article. So, what subjects should you look for when you use search terms within these sources, within these resources? Well, there are a lot of them, and these are just some examples here. Pharmacy technician supervision, generic substitution, failure to warn, compounding, prospective DUR, institutional controls, control substance diversion. So you want to use pharmacist or pharmacy along with any of these terms, and using the techniques you will develop yourself to find what it is that you need, you'll be able to produce legal case studies that will help you understand points of law, regulatory issues better, and will help you teach those points of law, those regulatory issues, to others, to pharmacists and to technicians. Now, we need to talk a bit about what it is that you will find and use. And we're going to have an example. In just a minute, I'm going to show you an example of a reported appellate opinion. That's really what we're looking for. An appellate court, a court of appeals, or a Supreme Court, either United States or a state, is reviewing a case and is providing its assessment of the case for us to use in improving the practice site that we're responsible for. Now, these are often called judicial opinions. When you see the phrase judicial opinion, you might say, well, that's just a personal preference that the judge or that the court has or that the panel of justices has. And it really doesn't mean anything other than their best guess as to what the regulatory requirements are. Not it at all. I mean, that's the law. It's a statement of the law on a subject. So even though what we'll be talking about are judicial opinions, they're opinions that are pretty forceful, pretty influential, pretty useful, that tell us what it is that's required of us. And we better pay attention because they mean it. It describes a case that really happened. This is what's really nice about the reported appellate opinions. These are not hypotheticals that someone made up. These are really cases, real people, real situations, real harm, real violations, real consequences. They're attention-getting in a way that a hypothetical simply cannot be. The facts are confirmed. The facts are established. So if you're wondering, well, who did what to whom, it'll be there. They'll tell you. Now, these are not immutable facts. It can be that later on, through further testimony, the legal system will discover that there's an additional fact, or that a fact that they thought was true was not. But at least for the purposes of teaching, you have a set of facts that you establish as the foundation of the assessment you're making, and you don't need to go fishing further for more facts. The names are not usually redacted. You may choose to do that. You may choose not to. But unlike medical records, legal records don't have the names redacted. Reported appellate opinions may serve as precedential authority. They're a precedent within a jurisdiction. Or they can be persuasive authority outside of a jurisdiction. So simply because you may be in Nebraska and a case that you're reading about is in Illinois or Nevada or California, and you know that it's not necessarily precedent setting for where you are, it's nonetheless persuasive as to what the rule would be and how it would be enforced where you are. And these are learning moments. Those really are opportunities, these cases are, for the people who weren't involved to think, wow, that could have happened to me. I'm sure glad it didn't, and I want to keep it from happening to me. So let's talk a bit about the procedural aspects of legal cases, because the process isn't self-explanatory, and you may have to explain it to the people who you are teaching. First of all, in a legal case, the plaintiff files a complaint, and then the defendant files an answer. That's not always quite as simple as that, but you'll see references to the complaint and to the answer. And if you need to know what a case is about, oftentimes you can find the complaint, which will be pretty specific, and the answer, which will include a lot of denials and lack specificity. What you may see is that there has been a motion to dismiss, that the defendant, perhaps instead of answering, filed a motion to dismiss, saying, this court lacks jurisdiction over the case. Or, for example, the statute of limitations has run. Just read what it is they say in their complaint. They can't possibly win because within their complaint they describe a legal question that can't be resolved by this court. There's going to be a period of discovery. There are no surprises, or there are relatively few of them, in legal cases. Depositions are taken, interrogatories are administered. I mean, pretty much everybody finds out what it is that the other person is arguing and the basis of it. And there may be a motion for summary judgment. This oftentimes happens in pharmacy cases. The pharmacist or pharmacy files a motion for summary judgment saying there's not even any reason to go to a trial, because now that we've done all of our discovery, we've seen that the way they have pled their case isn't supported by the evidence that we've seen in discovery, so dismiss the case without even going to trial. And then there's a verdict, perhaps, if the case goes to trial and isn't settled, after which there can be an appeal. And there's even either an affirmance or a reversal on appeal. If it's reversed, it can be remanded down to the lower court. The appellate court can send it back down to the lower court saying, do this again and do it right this time. Now, there are opportunities for interlocutory appeals periodically. What's important is what we're going to be looking at primarily, and what will be useful to you, is reported appellate opinions that are based on something that happened at a lower court and that is being resolved at the higher appellate level. So how are we going to go about this process of analysis with legal cases? There are a set of questions that I think it's important to ask and answer in a structured case analysis. You start out with, who are the parties? I mean, who is being sued and who's doing the suing in this case? It's important to identify who's who in a legal case with pharmacy regulatory implications. What's the primary issue? That's another question. I mean, really, what's going on here? What's the foundational issue of this case? And then, are there secondary issues? Usually there are. What are they? What are the facts? It's important before any sort of analysis of a legal problem occurs to agree on what the facts are, and that can be determined by examining the facts as the court states them to be within the reported appellate opinion. Then what are the arguments? What are the arguments of the parties? What are they saying? Obviously, somebody's unhappy. Why? Why is this person unhappy? And what is it that the defendant says the other party shouldn't be unhappy about? What was the result? I mean, that's important. Who won? Or who partially won? Then what was the rationale? What was the justification for the result? And finally, how can we use this case? How can we take the lessons that are learned in this case and apply them for our benefit? What we're going to do is run through this process with the case now. And the case is from the District Court of Appeal in Florida. So what you have here is the case caption. I've chosen a short case. This is a case that in the appellate reporter was about a page long. Most cases are 30 or 40 pages long, so what I've chosen to do, rather than make this a 5-hour webinar, in order to stay within the time frame that we have available to us, and in order to continue to have you be attentive to the material we're learning today, I've chosen a very short case, but that's fine. You can see how it is that these cases develop, and I think it'll be pretty obvious to you how it is that the much longer cases expand on the facts and expand on the issues. So here's the case caption. District Court of Appeal of Florida, 1st District. Michael D. is personal representative of the estate of Nicole D., deceased. Well, that's not good news, is it? Obviously, someone has died. So this is a death case, or an alleged death case. it's being brought against Walmart stores and Roberto Morales, MD. So the defendants in this case are the pharmacy and the prescriber, the physician. It often warms the heart of pharmacists and technicians to know the doctor's in it too. Don't worry. Now, this particular opinion that we'll be looking at, this particular reported appellate opinion, doesn't talk about the doctor. Instead, it focuses on the pharmacy. The pharmacy filed a motion to dismiss the case, and we'll see in a minute what it is that happened with that motion. Dr. Morales didn't file a motion to dismiss. So even though the case that we'll be looking at, the case report that we'll be looking at, doesn't mention the doctor, never fear, he's there. There will be, when this goes to trial, another person looking glum and concerned at the same table, if that makes you feel any better. So, here we have a death case being brought against a pharmacy and a physician. So, and this is language directly taken out of the reported appellate opinion. I've given you everything verbatim right out of the court's opinion. This is the statement of the case from the court. Michael D., as personal representative of the estate of Nicole D., deceased, appeals the dismissal of a negligence claim against Walmart stores for failure of the amended complaint to state a cause of action. So basically what happened was the pharmacy, Walmart, said this should be dismissed because it fails to state a cause of action. Even if everything they say is true, they haven't alleged that we've done anything wrong. And it was dismissed. The pharmacy wins at the lower level, at the trial court level. The case against them, brought by Michael D. as personal representative of the estate of Nicole D., was dismissed. He's appealing. So he's appealing this. And the complaint alleges negligence on the part of the pharmacy at Walmart in filling a prescription for Nicole D. We reverse, the court says. Okay, so there's a lot of information just on this slide. The primary issue is negligence. The primary issue is that this gentleman, who's a relative, perhaps the husband, I'm not sure, of the patient Nicole D., alleges that the pharmacy was negligent and that his case should not have been dismissed, and the Court of Appeals agrees, and they tell you right up front, we reverse. The lower court that dismissed the case against the pharmacy was wrong. We're going to reinstate the case. So what are the facts as alleged? Obviously, we don't really know what happened. We weren't there. But we do know, because the court tells us, what the allegation is. And it's the allegation on which this case is being decided, the allegations. Because the posture of the case is that even if everything they say is true, it should be dismissed. The lower court agreed with that position. The appellate court disagrees. Here's what they allege. It is alleged that Nicole D. received a prescription for a 50 microgram duragesic patch from her physician following a cesarean section. There was no time limit on the face of the prescription. More than 4 months later, Mrs. D. had the prescription filled at Walmart's pharmacy and used it to treat pain from a fractured ankle. A duragesic patch contains the opioid analgesic fentanyl. Mrs. D. died in her sleep as a result of a toxic overexposure to fentanyl. So those are the facts, or those are the alleged facts anyway. That's what the court takes as true for now in deciding whether or not to dismiss the case. The lower court deciding yes, we'll dismiss it. The appellate court saying nope, we're not going to dismiss. So here you see the facts. 50 microgram duragesic patch, evidently prescribed for acute pain following a C-section. Prescription wasn't filled for 4 months. Then it was taken into a pharmacy, and it was presented to the pharmacy in Florida, where, unlike some states, a Schedule II prescription doesn't expire after a period less than a year. C2 prescription in Florida expires after a year. In other states, some other states, a C2 prescription expires in a shorter period of time, not in Florida. So it's still a legal prescription, and the pharmacist fills it. The patient dies. So what the court does in evaluating these allegations is they refer to precedent from prior case law. And this is a useful thing. Ordinarily, in legal opinions, there are many, many cases that courts refer to. In this short case that I've chosen simply for purposes of illustration, it's an interesting case, but it also makes the point well for us in a webinar of this kind. There's only one prior case that the court refers to, and that's McLeod versus W.S. Merrill from 1965. They go up all the way back to 1965 for precedent. And what that case says is, a pharmacist must use due and proper care in filling a prescription. They reference McLeod versus W.S. Merrill. Well, seems pretty straightforward, but they have to go through the exercise of explaining it. When a pharmacy fills a prescription which is unreasonable on its face, even though it is lawful as written, it may breach this duty of care. Well, there's some important language there that you would want, if you use this in your teaching of pharmacists and pharmacy technicians, to dive into. Unreasonable on its face. Essentially what the court is saying there is that sometimes simply by looking at a prescription, a pharmacist can tell that it's unreasonable even though the pharmacist doesn't know anything else about the patient. The fact that there was a 4-month time span between the writing of this prescription and the request that it be filled makes it unreasonable on its face, according to the court. It is alleged that the prescription for this duragesic patch without a time limit for filling or using the prescription renders the prescription unreasonable on its face. Sometimes pharmacists have defended cases brought against them by saying, listen, I don't have access to the medical record. There are many things about the patient that I don't know and simply cannot know. So I wish I could have helped the patient. I wish the patient hadn't died or suffered whatever harm the patient suffered, but how could I have known these other things that weren't available to me at the time I filled the prescription? And here the court is saying, you didn't need to know anything else. This prescription was unreasonable on its face due to the time lag between its being issued and being presented to you for filling. So now, what is the judicial rationale? Judicial rationale in a short case like this is pretty sparse, but we'll see if we can take a look at it and figure out what the rationale must be. They don't really tell us, and this is an opportunity for us to glean what we can from what we have and understand about the case what we need to know in order to move in the direction of preventing this sort of thing from happening in our pharmacy. Here's what the court says. Again, this is verbatim, word for word, quote from the court. I'm giving you their verbatim language, not summarized by me, but their language and every word that they said. It is alleged that this duragesic patch, if used by one not on a fentanyl regimen, will likely cause hypoventilation, resulting in death. So, the allegation is that this is a patient who shouldn't have received this drug at this dose, 50 micrograms per hour, because the patient was opioid naive. Or at least the pharmacy had no reason to know that the patient wasn't opioid naive. It is alleged that a pharmacist viewing this prescription, which is more than 4 months old, would reasonably conclude that the patient is opioid naive, or the pharmacist would have no reason not to think that. The pharmacist should warn of this danger and or inquire of the physician whether the prescription should be filled for this patient. So here we have the solution, and this is important as an instructional matter. We have 2 possible ways to solve this with us not really knowing from the court's description of the solution which of those two, if not both, the court wants us to use. Warning the patient of the danger seems like one solution, and inquiring of the physician seems like a second solution. And what the court says is and or. I think what they mean here is that it may be that warning the patient results in the provision of some information from the patient that leads the pharmacist to understand that the patient is not opioid naive, that the patient is opioid tolerant. And if that information is forthcoming and the pharmacist can rely on it, then the pharmacist can go ahead and dispense and not inquire of the physician. But if the patient can't provide that level of insurance, then the pharmacist needs to inquire of the physician whether the prescription should be filled. And that's the only sense I can make of this, the and or explanation. It is alleged that the pharmacist did neither. These allegations of the amended complaint state a cause of action in negligence. Okay, so the failure to monitor for opioid tolerance in a patient who receives a medication that is at a dose that could indicate potential problems with hypoventilation is negligence as a matter of law. What's the result? The court says, we agree with the trial court that the pleadings do not sufficiently allege a voluntary undertaking. Now, voluntary undertaking is different from negligence. Voluntary undertaking is a legal theory that says, well, maybe the pharmacist isn't required to do this, but the pharmacist voluntarily undertook to do it, whatever this activity is. And having voluntarily undertaken to perform this service or activity, the pharmacist has to do it. The court says, we're not even going to think about that. And we don't even need to, because the activity that's alleged to have occurred was negligent. The decision of the trial court is reversed and the case remanded for further proceedings consistent with this opinion. So the case went to trial, and the pharmacy won this case. Eventually, which we don't have in this opinion, or a summary of it that I've given to you, the facts turned out to be very different from what the plaintiff alleged them to be. And as a result of these different facts, which I recommend you Google and discover on your own, the pharmacy won the case. So, how can we use this case as a teaching opportunity? Well, there are several important ways to do this. And depending on the state you're in, you might use it in one way or another. It may not be useful to you at all, particularly if you're in a state that has a time frame after which a Schedule II prescription expires. I think you can still use it in the state for the general principle. The general principle being that filling a prescription that is unreasonable on its face, even if legal, breaches the pharmacist's duty of care. You have to look at a prescription critically and ask yourself, does this make sense? Are there aspects of this prescription that, not knowing anything else about the patient, cause me to understand that the prescription is unreasonable? And if the answer to that question is yes, then despite the fact that the prescription is legal, filling that prescription without talking to the patient and or talking with the prescriber breaches the pharmacist's duty of care. More specifically, the question deals with the opioid non-tolerant patient or opioid naive patient being at risk if that patient receives a prescription that exceeds what the package insert describes as opioid tolerance, 60 milligrams oral morphine equivalent daily for the past 7 days. So this is an alert to pharmacists and pharmacy technicians that in managing drug opioid therapy, pain management for patients, it's important to understand whether or not there is evidence in the record that the patient is opioid tolerant, and if not, then some investigating has to be done if the prescription presented for filling is at high enough level to warrant that investigation. The regulatory response to this could be that in the instruction is either warn of the danger, talk to the patient, or contact the prescriber. And this is not an emergent situation. This is not a circumstance where the patient is going to die for want of fentanyl. You have time to figure this out. Physicians aren't waiting at the phone for pharmacists and technicians in states where technicians can make this call to contact them requiring explanation. So get the explanation rather than simply deciding this is something that has to be done. And then what we would do in pharmacy is ask, what can we do? How can we work with IT, for example, and get better support from them? What sort of literature do we need? What sort of communication strategies can we use in order to meet these challenges? So let's sum up here. There are several important things we know from this lesson. One of them, an effective pharmacy regulatory specialist will use education as a compliance tool. It's all about education. It's about communication. It's about cooperation. It's about collaboration, but education is the key. Legal case studies are in the public domain, and they offer an opportunity to educate pharmacists and pharmacy technicians on regulatory compliance. Thirdly, there's a specific method to use in presenting a legal case as an educational opportunity. These things don't teach themselves. They have to be explained. They have to be taught. They're complicated, and pharmacists and pharmacy technicians have to be led through them by a pharmacy regulatory specialist who's thought about it, given it careful consideration, and shows the important aspects of it and explains the procedural nuances. And then lastly, legal case studies are not just interesting. They serve as the basis for changes in practice that reflect general principles and specific challenges. These case studies are available to us. We might as well use them. And if we do, we can prevent these tragedies that have happened to others from happening to us, to the prescribers we work with, and to our patients.